I'm saying, it's an issue.
The governor asked for a trust vote.
Yes.
Two ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government.
Pinpointing, picking out a person and saying.
Picking out a person, because
Correct.
even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. There was no valid material at all on the basis of those three circumstances.
That's a core question. And that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet. But perhaps he didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to galat fehmiyan aur bhi badhi. Usne wo bhi suna jo maine kaha nahi. Usne wo bhi suna jo maine kaha nahi." The governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 where the resolution is held there. So he's hearing things.
The resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta, not Bashir.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very.
No. I'll be dealing with Bombay. That's the core question. Your lordships is saved a lot of unnecessary exercise if your lordship comes to that conclusion plus follows Bombay, which in any case is.
So then you, according to you, what? We reinstate the Uddhav Thackeray.
Straight away, let me change my tack and go to Bombay.
But you resign, no?
No. I covered in my note directly. 5 reasons. Justice Shah asked me that in the beginning. Your lordship asked me that. I'll straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant. Completely.
But that's Ms. Dr.
No, I'll deal with it. So let me deal with it. So let me deal with that.
It's like the court being told that you reinstate a government which has.
No, it's
acknowledgement by you.
I hear your lordship loud and clear.
Resign.
It's a question asked earlier, and it is actually a plausible looking thing, but it's actually irrelevant. I'll show that in a minute.
No, Mr. Kapsil. How can, just hypothetically,
yes.
How can the court reinstate a chief minister who did not even face the floor of test?
Your lordship is not reinstating anybody.
Then what will be the consequences?
Your lordship is and should and does, and Bommai says it more graphically, restore status quo ante. That's the meaning of a.
But Ms. Dr. Singhvi, it would have been a logical thing to do. That's where we are, it would be a logical thing to do, provided you had lost the trust vote on the floor of the assembly.
Lordship may just flag that.
Because then clearly you have been ousted from power because of a trust vote which is set aside.
Correct. Duty bound to satisfy Lordship, and I believe that.
Right. Now our problem is look at the intellectual conundrum.
Yes.
That it's not that you have been ousted from power as a result of a trust vote which was wrongly summoned by the governor. You chose not to, for whatever reason, you didn't want to face the trust vote.
I face that squarely. Allow me, I'll change my sequence and come to that first right now. May I, because straight away your lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law your lordships. If your lordships comes to the conclusion of the other one. Give me just 5 minutes on this. May I end the first part, That is, this affirmative and negative code.
Yes,
with only one.
Now, Dr. Singhvi, we are 17 minutes past or 18 minutes, closing on 18 minutes past 3 p.m.
Tuesday,
I think 3:30 we'll close now. I think we have seen everything now.
No, I'm asking, 3:30 is now 3:20. I've done 1 out of my 7 points. This is a matter of some moment. I'm not going to
conclude. I mean,
I can't just go in. Conclude, but it is a very useful, when your lordship asks questions.
Your points are really alaps of your.
No, with respect.
You are in rejoinder council.
I have argued 1 out of 8 points. I would not otherwise take time. And your lordships, it is not intended to stop your lordships querying, because your queries actually make us think.
All right, Dr. Singh, you are always very precise. You are always very precise. Now go on to the next point.
Your Lordship's compliment is intended to render me speechless, Maharaj. I'm not going to be
No,
speechless.
no. No, it's not
Allow
like
me,
that.
Maharaj, a few
Dr. Singh,
minutes.
there's too much. The point is,
This is,
there is a lot of stuff that we have to reflect on now, and we just want you
so
to now
maybe Your Lordship will just
in
give a
rapid
little over
fire
4 o'clock.
summarize it for us so that we can have.
Let me speed along, and Maharaj, Your Lordship may give me a few minutes after 4 minutes. See, I am very keen to finish, Maharaj. I'm not, till now, Maharaj, I have not repeated a single point. I've given Your Lordship two facets.
Now not interrupt you. Go ahead.
Yes. So, well, let me end this first point by saying, let me end the first point by asking myself a reverse question. What happens in my first point of affirmative and negative if Your Lordships were to accept their interpretation? That's a good way of answering my Maharaj's proposition. Namely, Your Lordship will have nothing left in the 10th schedule. How does Your Lordship operate both? The 4-step or the 3-step becomes the norm and will be followed in every case to defeat the 10th schedule. That's my first point. Second point on resignation. Now, Maharaj, Your Lordship also has to deduct Maharaj 220 my learned friends for occupying Your Lordships. And now, Maharaj, now the second point. Just look at this resignation trust vote a little carefully, Maharaj. I have 3 or 4 answers. It is irrelevant for the following reasons. But just turn to para.
Singh, the reason why we are wrapping you up, so to speak, is not because you have no case. We have
No, Maharaj. I
asked you to wrap up only because now the burden shifts heavily on us to, as adjudicators, to apply our mind and step back and
so let me, Maharaj, now
decide.
speed up. I think, Maharaj, oral things help, but to speed up, let me ask Your Lordship to read para 14 of my note, A7. Para 14.
Just formulate it for us.
Yes, the formulation.
We've now got a.
When, Maharaj, now I'm answering the second
14,
head.
page 7.
I had 6, 7 heads. This is my second head.
Education.
And it starts, Maharaj, this head starts at page 6. It starts at para 9, page 6. Resignation.
The act of resignation.
The act of resignation subsequently on 29 June would not defeat and would have no relevance to the reversal of the illegal action of the governor of 28/6. And in accordance with precedent, this honorable court should effectuate a real and meaningful remedy. Now, Maharaj, Your Lordship recollects my A3 submissions, para A to N, which are repeated here. I argued, Maharaj, ibi jus, ibi remedium, fait accompli, status quo ante, all that. I'm finishing off in one para. I'm not arguing. I'm just reminding Your Lordships. Now, skip all that and come to, Maharaj, para 14 for a minute. Does my Lord para 14? Once the illegal act of the governor is allowed to be implemented, the result was a known and foregone conclusion. Factually, there was no need for the ex-CM to subject himself to it. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act,
Yeah.
the consequence of that is known to me. Now, just to save time, let me read it. The crux of the issue raised in the petition, where Lordship has got 14A, Malas, 14A, third line. The crux of the issue raised by the petitioner remains that the direction to hold the trust vote was an illegal act because the governor did so by recognizing a faction of 34 legislators. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, so prior is important, and pending in a court, a participation or absence of participation ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote, it would make no difference in law because the trust vote was merely the consequence of the illegal act of the governor. And the challenge would still relate to the governor's actions and not to the trust vote. D, it is therefore obvious in law, Malas, that the consequence of an illegal act, emphasis on consequence, cannot determine the legality of that act or validate it. Indeed, it could also be said that the petitioners, having challenged the core illegality at the base, namely the governor's actions, without any delay, did not even need to challenge the trust vote. I could have said it's nothing but a consequence. Similarly, if the individual illegal actions are broken up and there are different interpretations, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor in inviting and administering oath, the participation or absence of the ex-CM has no relevance. Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para
So this is the second point, no,
this
Dr.
is the
Singh?
second point, but just one thing is left here, Malas. Para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law EBUs, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, Malas. In that, kindly, Malas, do me the favor of treating it as having stated here. Now, Malas, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Malas, Karnataka and Meghalaya, is very important, is liable to be struck down and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have been happened in the intervening period. Now, just this is very important. This has not been shown to your lordship. Just give me a minute. 398, another 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 356 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the lordship holds the governor to be bad, then a person not entitled to be holding the post of chief minister. How can, of all courts, the Supreme Court accept such illegality? If your lordship's powers are unique in this country, in that even your lordship's can go beyond the law, not contrary to law, beyond the law. Then, what's the point if the governor's actions are held to be illegal? Actually, your lordships would be giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now, let's just see next one. In state of Meghalaya, it's very interesting, for the other state in Bomai, para 12 of my note. Again, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored in Meghalaya. We would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted and all, no relief is granted consequent upon the declaration. Therefore, Malas, this is the heart of this point. Now come to Malas, page 1 on 189. The third point is 189. All right. That is coming separately. That's coming separately.
What is the point, Dr. Singhvi?
Yes. Now, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued, I believe.
189, I'm sorry to interrupt. What is 189? Dear?
No, page 1.
Page 1 of my note. That is one of the de facto doctrine that actions validated by the actual act, which is challenged is illegal. I want to show how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. Malas, the first important thing is to note that there are 2 kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Malas? Mr. Malas, friends, 2 of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
189 is said in the context of the vote in the House.
So,
with respect to
exactly. So, therefore, no. 189 your lordships can and may, and in this case perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, Balas. I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra
you're really
government
saying
made a
is,
liquor policy,
Dr.
therefore
CP,
that is
what you're
gone.
saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
Subsequently found to be invalid.
Correct.
But that does not validate the original appointment
That's
itself.
that's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for that goes back to the same thing, Wallace. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote, Wallace. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot
What you're saying is that if the calling of the voting in the house itself is subject
That's
to their.
just how my lords formulated was, right or wrong. Governor's action, A, no basis, and B, if basis, well, it is wrongly applied, etc.
But that's affirmation of the house, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bommai dealt with the affirmation.
All right.
Bommai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, it will be quashed. Can you come to that now? So first, well, let's come to, yes, I'll just show 50. Just keep 356. Sima's query answered by Bommai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there's nothing. There was a presidential proclamation affirmed by Parliament in Bommai. Now come to Wallace para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected in Bommai. Does my lord have it, Wallace? Para 4. Do my lords have it?
Yes.
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court held a clear majority, 5 judges, Wallace, that if a proclamation on 356 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 289, 189. This is express approval. This is express approval. Now read this para. Very interesting. 110 Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bommai has a.
Now there is one interesting, very interesting. After 29 years and 2 days, this is happening in a lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books below say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singh.
No. This is, we've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out. Then Wallace, the SCC
Dr.
issued a
Singh,
corrigendum.
I must also publicly acknowledge there's a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that, we are all,
It's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus. It's just a love for the job that they do it.
The time, money.
Private sector is
Your lordship is entitled to judiciary. Right, Wallace.
Batao. You are part of them.